I just had a case with a local attorney who's a pretty aggressive attorney and really fights for his clients, and I respect him immensely for that. Mm-hmm. But we got to the conclusion of this case. It was very, very obvious that his client was using a great deal of very high-end violence, strangulation, a gun, gunplay, a lot of very dangerous stuff. And we got to the end of the case, and we were, wrapping up our agreement. We're going to put him on the record. And I just sat with him. I got my trial notebook out, and his paralegal was there. And I was like, listen, I know you probably looked at these to prepare for today, but we're going to look at them together. And I turned to the photographs, of my client's injuries and also a subsequent victim. And I was like, now that we're done with he didn't do this, or, she's making, now that we're done with all the theatrics, right? Let's have a really honest conversation about what your guy's doing, because he trusts you. Right. And he respects you, and you're a man, and you can talk to him and tell him that he is going to murder someone, that when he puts his hands around someone's neck like that and squeezes to the extent that they have injury on their neck and they're defecating or they're urinating on themselves, that he is that far away from killing that person. And, he will end up in prison, and he will end up with all of the regret of continuing this behavior. And you're in this really powerful position. And, that attorney emailed me the next day and said that was a very meaningful exchange for him, and that he agreed with me, that he agreed that he had a position of authority and respect in this person's life, and that it was very important for him to really try to counsel and mentor his client to try to prevent that future violence. And that is good legal representation.
We've had some really
not nice people.
I was going to say harsh conversations, but they were conversations that needed to be had, that these particular individuals had never been put in a position where they had to have those tough conversations.
That's right, because often the people surrounding them don't create any accountability, right? So one of my favorite topics, I could write a book about abusers' moms. Hello. How many times have someone that's using violence come into your office and their mommy is paying for their legal bills and, telling you all about how terrible she is? And part of that is because typically, when someone's using violence in their adult relationships, it's very often because they learned it, right? So we know that it's not a genetic thing. It's not a mental illness to use violence in a relationship. There can be correlation between mental health and the use of violence, but it is a choice. And the reason I know it's a choice to use violence is because it's not an anger management problem that you're controlling the amount of money she gets. It's not an anger management problem, when she doesn't have a car in her name or she doesn't have freedom of movement, right? Those are not anger management issues, right? Those are control and domination issues. Also, we know that it's not an anger management issue because this person navigates the world really well. They go to church and they're well respected. They have a job that they've had for many years. They do not behave this way in other environments. So in fact, that person has incredible anger control. They're able to use their rage and their anger in very specific moments to accomplish something. And what they're trying to accomplish is dominance.
Right.
If you're afraid of me, then I get what I need and what I want. And so it's a very effective tool in a relationship. So when you have an attorney that is willing to be, listen, hear their client out, be sympathetic to their situation, but also honest with themselves about what they're dealing with, and able to have frank communication with their client, it could be the very first time that someone has ever said, hey, dude, like, I know that, this is probably something you watched growing up, right? I know your dad was arrested for family violence 15 years ago. I know you went to a shelter when you were 8. Like, you have come by these choices and behaviors honestly, but dude, you've got to change these things because they're not healthy for you and they're very, very harmful to your children.
Right.
Your children, whether you believe it or not, right? Victims will tell me, perpetrators will say, kids aren't in the room, they weren't there, they're upstairs, they're not seeing it. He's maybe very selective and private about his use of violence, but children are sponges and they absorb that trauma in their home and it plays out in their adult life. And so so when an attorney is doing a good job with someone that's using violence, and not just the physical violence, but really able to say, hey, this is what they're saying. Like, here's some examples of coercive control. Are you doing this?
Right.
And you can tell me this is confidential, but are you tracking her? You make $100,000 a year, bro. Are you giving her $200 a week on a debit card? Is that are you doing that? And if they are, and they're willing to be honest with you, then you can say, like, these are all indications of abuse. This is not about you just losing it. This is tactical.
And we've had cases where, one of us will try to have that conversation with our client, and because, sometimes I'm a woman or sometimes because Floyd's a male, it's not hitting home, and we can identify very quickly, like, they're not listening, they're not understanding this. Right. And so, Floyd will call me or I'll call him and we'll say, well, we need you to call this client because and then what ends up happening when they don't listen to us, they dig themselves a deeper hole.
They do.
And it's so difficult.
My favorite cases.
So yeah.
My very favorite case. Listen, I should be allowed to have some fun in my job. And when these guys just dig in and they don't listen to their very good representation and they insist on, I can't tell you the number of good deals that I have offered before we walk into that courtroom. But again, when they're about dominance and control, they are not going to be told. They're not going to be told that they're going to have limited access. They're not going to be told that they have to go take a class. They're going to dig in and insist on their perception. Sometimes it's, narcissism. Sometimes it's not. But the number of offers that I have made because my client doesn't want to, she doesn't want to go in and, testify about the most personal, intimate details of her life with him staring at her. She's terrified. So I make some pretty reasonable offers. And the number of times that those have been refused and we have gone in and I have just been able to take that person apart, and get way better result than what we were offering before we walked in the door, is countless. And it is very often these guys who just won't listen to their attorneys, because I know their attorneys even you guys are zealous. Like, you represent your folks. You don't lay down. You don't, you represent your folks. You do a good analysis of what you think the judge is going to do. But when they don't listen, it's so obvious they're not listening, right? It's just, even though no lawyer would ever say that, would ever be like, oh my gosh. Every once in a while, a lawyer would be like, we're going to have to go have a hearing because I can't sell this deal.
Listen to me.
Yeah. And sometimes it's true for me too. Like, I have clients that, and you've probably seen this because I'm sure you represented victims too, that once they're ready to kind of start talking about what's been happening to them, they expect to be believed, which is normal. I have a tremendous amount of empathy for that, but helping them understand that we still have to prove it, right? That just because they're telling me that may be okay for their friends and family and the support they need, but when we're going to go in front of a judge, like, I have to establish these things, and he is going to have his own narrative. And as you guys know, there's no perfect client. So there's always challenges, even with my clients, there's always things that I'm going to have to, manage around when we go have a hearing. And I sometimes have clients that have really unreasonable expectations about what can be accomplished, and they just have a lack of trust, which again, I get, and they also don't know what they have. And it's another thing, when you're a free lawyer, sometimes people underestimate your capability.
Yeah, we were on the court appointed list.
Yeah, people think if you're, sometimes they're like, well, you're, a legal aid lawyer, public interest lawyer, and they don't fully recognize like the amount of, capacity and capability that I have in my job, so they have a little bit of a lack of trust, and so they want to have a hearing.
I'd much rather them hire somebody else other than go to legal aid here in Denton County.
Well, yeah.
You guys didn't want to do it.
Go hire a cheaper attorney.
Yeah. Well, we love legal aid at Friends of the Family. They're one of our partners here. They are as overwhelmed as we are with the number of cases that they take and that they have to represent. So we're just all kind of trying to figure it out. But when your client's expectations are unreasonable, that can often lead to a bad result for them, right? You tell them like, I really I can't absolutely predict what the judge is going to do, but I can tell you what my experience tells me about what's going to happen here. And this idea that he's going to be denied complete access to these kids based on the facts that we have, it's very rare for me to get a no access order after a contested hearing. Right. Like judges, I think, believe that they can, control the safety with a supervision piece, and in most instances, I think that's pretty true. There have been some pretty dangerous instances of violence during supervised visits in other parts of the state. We have some really good supervisors here in Denton County, and but most of the time, I have to deliver that news and say, like, this is probably the way this is going to go, and sometimes people will hear me out and sometimes they won't. And at the end of the day, sometimes clients just kind of have to hear it from a judge.
Yep.
And that's where judges are very useful, I think. If they are good about if they're good about communicating, like having like a good, firm but not abusive communication style. So if you have an abusive communication style as a judge with a victim, with the survivor, it's not effective. Right? But if you have a firm communication style that's fair and equitable, and there's a measure of kindness in it, that can be very effective for one of my clients, because the judge is having that communication with both parties.
Right.
And so that can be pretty helpful.
So the change to the protective order statute.
Yeah.
You want to speak on that? What happened?
Sure. So prior to September 1st, right, we had to prove that there was family violence that had occurred in the past, and then it was likely to occur in the future.
Yeah.
Starting September 1, they removed the likely to occur in the future, right? So now just showing family violence has occurred is sufficient for a protective order. Now, what I wanted to talk to you about was the distinction, right? Because you have family violence, right? And then you have domestic violence, which is a much broader term, right? And so family violence specifically dealing with, bodily injury, right?
Yeah, physical assaults, threats of imminent physical assaults, and sexual assaults and threats of imminent sexual assaults. And then they're in the family violence definition. There's also some child abuse cross-referencing, but that's mostly around physical injury to a child or sexual assault of a child. Doesn't include the provisions around emotional abuse and things like that.
So when you're dealing with, psychological abuse, emotional abuse, things like that, how are you able to navigate that through protective order?
Yeah, so probably we wouldn't use a protective order as a tool in an emotional abuse case unless a part of that emotional abuse includes those threats, right? So if we can establish that, a part of the emotional abuse that's occurring is the use of threats, right? So, threats to kill, threats to harm themselves, threats to harm children, threats of that physical assault or threats of that sexual violence, that's a protective order that we might take. And in those cases, we might, get protective orders now that we wouldn't have otherwise gotten because that second prong is gone. I think, one of the reasons that happened is that what a lot of what those of us who do this work a lot, who file lots of protective orders across the state, including district attorney's offices. So I do want to tell your, viewers that one of the things that makes Texas unique is that our county attorney and district attorney's offices are tasked with providing representation to victims in protective order proceedings. And so in Denton County, we have a really excellent protective order division at our DA's office. The lead attorney there is a woman named Caitlin Milmo. Mm-hmm. She is exceptional at what she does, very good, and she has really good support staff. Mm-hmm. And so there's no cost to that. Mm-hmm. So if someone is seeking a protective order and they're maybe coming into your office and they need a protective order and there's really nothing else they need and the evidence is pretty good, I generally think that you should be sending those folks to the DA's office, because I do think there's a little bit of an ethical question of taking $3,000, $4,000 from a victim to do something that they can reasonably get for free. Mm-hmm. Now, there are reasons why attorneys might want to take those cases. So in protective orders in Texas, the statute allows you to get child support. It allows you to get spousal support. It allows you to address property issues, right? Possession of children. Now, our DA's office will address possession of children, but they're not as likely to address support issues. Right. And so, if it's an investment, right, if I can come to you guys and say, I need a protective order, but I have no access to the community, once I get this protective order, I'm going to be cut off, and I need access, but I'm not ready to file for divorce, or I don't want a custody order right now. I just want to address my safety, then it might make sense to use some funds to retain an attorney, because that private attorney is going to be better positioned to make those arguments about child support and about spousal support, because a lot of DA's offices that handle protective orders just won't even get into that stuff.
So let me just ask you from a practical matter, how does that work? So somebody decides, I want to get a protective order, I can't really afford one, and they want to go to the DA's office. What do they, how does that work?
Yeah, well, here in Denton County, my great suggestion is that you contact Friends of the Family. So our website is www.dcfof.org, and there you'll find our crisis line number that's answered 24 hours a day, 7 days a week. You can actually text us there as well. We started that during COVID because a lot of victims were stuck in their homes with their abusers and they couldn't make a call. So we started operationalizing texting so that they could safely communicate with us. If they contact the agency, they should get an intake typically within 48 hours. If it's urgent and they need one right away, we're really promoting just walking in. Our office is in Corinth at the corner of Post Oak and 35, our outreach office. We have separate shelter locations that are confidential, obviously, but our outreach location where I office is just at 4845 South I-35E, just at Post Oak and 35. And we're really promoting that if you really have a dangerous situation and you need to talk to someone, just walk in. You can walk in. We have intake folks. We should have the availability to pivot and help you in that moment. But what will happen for us is, and why I think it's valuable to come through Friends of the Family instead of just walking into the DA's office, which you can do. You can just, if you guys had somebody and you're like, you need this right now, and you wanted to circumvent the process that we would have, you can just send them directly to the DA's office. It's at 1450 McKinney Street in Denton on the 3rd floor, and they can just go right in there and ask for an application and apply, attempt to apply for a protective order there. What I think the value of coming through Friends of the Family is they're going to get an intake and they're going to immediately assign to an advocate in our agency who is going to help help them with that application. Sometimes victims aren't great about articulating all the things that they need to articulate in order for the DA's office to accept the case for representation. So they're going to help them with that application. And the other thing that we do at Friends of the Family is we draft the affidavit. So all of our advocates are skilled in drafting that supporting affidavit that's necessary to get a protective order. And we then send that over to the DA's office. They may tweak it or change it after meeting with the victim, but we can do a lot of the front end work and move it. That way we can move it along more quickly.
Right.
You were talking about their inability to articulate what was going on. And so we've had some cases where they didn't realize they were being abused or the extent
That's right.
abuse,
Yes.
right? And so they'll come for a SAPS or a divorce. Like, no, let's do a PO first.
Yes.
Let's get that out of the way. That way, when he's served with a SAPS or a divorce, you're protected.
Yes.
I know we've put in processes, flagging cases and code words, passages and stuff for victims. And so how do you guys handle that? Like you're talking about texting at home.
Yeah.
How do they do that in a protective manner?
Yeah, so I mean, a big part of what we do at Friends of the Family is safety planning. What I do is legal safety planning, but what our advocates do or what our intake folks do is more broad safety planning. So they're going to identify where the points of concern are and help that person make a plan. And it's going to be, it's very customized depending on that person's circumstance. Most of the time when someone is seeking a protective order, what we're immediately going to address is sort of their physical location, right? At my agency and in my representation, if someone, doesn't want to, leave their home and, and we can't come up with a good, safe way of filing this, either protective order, or custody, or divorce, it may not be a case that we're ready to take. So often we need to come up with a plan for what's going to be that sort of temporary plan until we can have you safely here. Sometimes that means really pursuing the criminal justice route. So let's say someone comes in and they said, well, I called the police and he left and they took pictures, but I haven't heard from them, right? A big part of what our advocates do is that criminal justice advocacy. So they pick up the phone, they call the police department, they talk to this. We know, we have very good working relationships. There's like 36 police agencies in Denton County. There's a lot of them.
36 police agencies.
There's a lot. But the big ones, right? Denton, Louisville, the Colony, those are our, Denton County Sheriff's Office. Those are sort of our big agencies. We have working relationships with all of them. So we would call and say, hey, you have this report. What detective is it assigned to? And we start helping that victim have that communication so that they can get a warrant, right? And once they get a warrant for that person and take them into custody, then we have access to a whole other kind of protective order, which is very useful, which is called a magistrate's order for emergency protection. Those are usually anywhere between 31 and 91 days, and they issue while that person is in custody. So they walk out of the jail having been served with a protective order that says you can't go back to this address. Well, that's great for our client because it really serves the purpose of not having to disrupt themselves and their children's lives to have to go to an emergency shelter or go couch surf at a friend or family. And now we have a protected environment, and then we can start talking about a more permanent protective order, and it gives us some time, a little bit of breathing room in which to do that. So depending on the person's situation, depending on what resources might be available, that safety plan can look really different. But to answer your question about, or to comment about people not really knowing what they're in the middle of, that is absolutely true. I mean, we have screening tools that we use, and it's really common for a victim to come in, and they come in for a very acute reason, and then we have this little checklist that is boxed, and it says, verbal abuse, emotional abuse, sexual abuse, physical abuse, and it's a bunch of different things, right, that you can check boxes. And that's usually that aha moment for someone where they're like, checking boxes, and there's the obvious stuff that we all know is abuse, right? Oh yeah, he's pushed me, he's strangled me, he's pulled my hair, he's hit me in the face.
That we know, but it's crazy to me that sometimes when I'm talking to some of these victims, they're like, "Well, I mean, are you a victim? Like, has he ever hit you?" No, he never hit me, but he pushed me to the ground, and he grabbed my phone out of my hand and he threw it at me.
Right.
But it didn't hit me.
Right.
And it's like, though it's like, well, you're minimizing.
But that's really common, and if you think about why that is, right? Like, why would someone that's being victimized minimize that experience? And the reason for that is we all want to feel some level of agency and control over our lives. And if we can accept some level of responsibility for what's happening, or we can minimize what's happening, it does make us feel like we have the locus of control. And so that's why we use that tool, because it's not judgmental, right? It's like, these are factual. We're not telling you this is abuse. We're saying we just want to know, like, of all of these things, what has happened historically in your relationship, and just the filling out of that form sometimes is the transformational moment where you can see the kind of almost the blood draining out of someone's face, right? Of like, oh my gosh, I didn't realize that this was abuse.
Right.
I grew up seeing this, or there is so much that just in our culture is minimized. Yeah, we can look at a victim and say, God, why is she minimizing? But she can share the same information with the cops and they can minimize it.
Yes.
So if CPS is minimizing, if our criminal justice system is minimizing, then why wouldn't we expect that she also minimize, right? Yeah. And so part of it is just like using a tool that allows people to kind of just factually tell us what's happening. And then that gives us a sense of lethality. And then in the intake, we use a domestic violence assessment tool that is a little bit more narrative in nature, that is broader questions that allows somebody to more narratively talk about what's been going on. And a lot of those questions are from like evidence-based lethality tools that have been created by, fancy people that, study all this
really,
stuff.
Really smart people.
Yeah, they're really, really smart people. Jackie Campbell is one of them, who spent her lifetime, her professional career studying this and creating these lethality or danger assessment tools. So there are certain things we're looking for, right? Like access to firearms, threats of suicide, unemployment can be a potential connected to other things that can be a real concern. Sexual violence, stalking, we haven't even talked about, except the tracking, right? Which is stalking, right? Like that is stalking. And in Texas, we have a stalking protective order. So in answer to your previous question about like the emotional abuse piece, usually with emotional abuse, there's all kinds of other stuff happening. And so we're going to be looking at sexual violence. A lot of people aren't going to consider themselves raped, right? But sexual violence isn't about forcible rape. Sexual violence is on a continuum. It's a lot of different behaviors. And so we might identify some red flag sexual violence or sexually abusive behavior, forcing someone to do things they don't want to do. What a victim may not consider sexual assault is sexual assault. I cried. I told him I didn't want to. He didn't take my no, and he had sex with me. Well, that's sexual assault, right? Like, so sometimes it's just having those conversations gently and saying, hey, let me talk to you a little bit about what sexual assault really is. I know on TV and even in our community, we talk about sexual assault like you getting grabbed off the street and pulled in an alley and sexually assaulted, but that is not the story of sexual assault in the United States. Like the story of sexual assault in the United States is overwhelmingly acquaintances, dating partners, and intimate partners in long-term relationships.
And the misconception that if you're married, it can't.
That's exactly right. And, that misconception exists because for many, many, many years, much later than any of us would be comfortable with, you could sexually assault your partner and it not be a crime, That's right, your spouse, and it not be a crime. And so, it has been a crime for the entire time that any of us have been practicing law, maybe except Christina, I don't know. Yeah. So, but so looking at those red flags, so any use of sexual violence, strangulation is a huge lethality indicator. And again, that's also something that can get really minimized because depending on when that use of strangulation is used, if it's used in anger as an assault, but sometimes strangulation is used as like in a sexual context, right? And it's not wanted, and you actually can't consent to being strangled, right? No matter what your clients might tell you about why he strangled her, it was something that they were doing to receive pleasure in a sexual context. It's incredibly dangerous. You can't consent to it. It's a crime, right? And so educating people about that, the danger of that, and just that moment of like, oh yeah, I mean, I've told him I didn't like that, but he wouldn't stop. He there's something about that he enjoys. That's also a lethality indicator, right? Like that's a thing for us that we're going to go, okay.
Right.
So with stalking protective orders and sexual assault protective orders, the standards are different. And so we actually just went through a statutory change on the definition of harassment and the definition of stalking that further clarifies what those crimes are. And those protective orders, stalking protective orders, are in the Code of Criminal Procedure. And in order to get those protective orders, you have to prove, basically it's a reasonableness standard. There's no imminent future harm element. It's a reasonableness standard, whether or not there's reasonable grounds to believe that stalking and harassment have occurred, or the same for sexual assault. So we may use, if we have what looks like emotional abuse, he's not physically abusing her, right? He's not hitting her, leaving her with bruises, injuring her. But she talks about emotional abuse, and we dig into that a little bit further. We kind of figure out that there's a lot of coercive control, and included in that is some sexual coercion, some sexual violence, and then these stalking behaviors that are happening. And so we may go the route of a stalking protective order or a sexual assault protective order versus a family violence one.
And the stalking protective order is something I don't think family law attorneys use enough.
They don't. In fact, we just did a CLE a couple weeks ago with some attorneys here in Denton County to talk. Caitlin Milmo and I, we were doing sort of an overview of protective orders, but we spent time on the stalking protective order because we think it's a very underutilized protective order because it is virtually the same order, right? It's the same sort of prohibited behaviors, but it's an opportunity for us to get in front of a court these other behaviors. So what we will often do is plead family violence and stalking in our protective orders, which then opens up the evidentiary world to talk about some of these other more concerning behaviors. And so it gives the judge options. Are they going to find family violence, or are they going to, do they not feel like they can find family violence, but they could find stalking based on the statute? And the stalking statute actually incorporates the harassment statute. So if there are folks out there that want to know, like, would they be able to get that kind of protective order? Just looking, just Google, the Texas stalking statute and make sure that it's the 2023 version, and it will articulate all of the ways that, the court can hear evidence about stalking. And stalking and sexual assault protective orders are only 2 years if the date's not. It's like presumed to be 2 years if it doesn't have like a termination date. But otherwise, both of those orders, without any additional evidence, can be up to a lifetime. Versus family violence protective orders, in order to get something beyond 2 years, you would have to prove, it'd have to be a serious bodily injury case.
Or a weapon.
It can be, because the reason why a weapon is it's also felony level domestic violence. So if you can establish felony level domestic violence, then you can at least request a longer than 2-year protective order. And what's felony level violence? I mean, continuous abuse of a family member. So if you have 2 or more incidents of family violence within 12 months.
Hey, even if they haven't been charged with it, just 2 instances within 12 months.
So important. Such a great point. I'm glad you pointed that out, because across the board, whether it's a family violence protective order, stalking protective order, sexual assault, you do not have to have police reports. Now, in some jurisdictions, when the DA's office is doing it, they can have their own internal policies about what cases they will take. And sometimes you have prosecutors' offices that will limit them and, make determinations about violence has to have occurred in the last 30 days, or there has to have been a police report. That's not statutory. That's not the law. That's a limiting policy for the DA's office in order to probably be able to do protective orders, is they have to come up with, what kind of criteria they can handle in terms of volume. But you do not do police reports help? Often they do, right? Especially if you have good responding police agencies that know how to investigate a family violence offense, that take stalking seriously, and are documenting that well. Those can be helpful, but you do not need police reports. But the penal code definitions are the definitions used for the establishment in a proceeding. So even if you don't have stalking reported to the police, or you've reported it to the police, but they don't understand stalking, they haven't been trained well, they are minimizing the behavior, and this happens a lot in family violence, right? Because our clients have kids together, and so it's easier sometimes for police to be like, oh, this is just a custody dispute, this is just about kids. And my conversation with police is like, well, I mean, if a victim is leaving and she has children, then necessarily there are going to be things about kids. But you can't say that there's not concern because of these children. You have to kind of push past the fact that there are potential contested custody issues, and look at the behavior of the person. And so is it harassing? Is it stalking in nature? Or is it just someone really desperate to see their kids? Right? And you have to be able to make those distinctions.
Or even if a criminal case has been dismissed. Right?
Yes.
Because I've had attorneys argue, they had a criminal case that was dismissed.
Yeah.
I'm like, I don't care.
Right.
How is that attorney saying they couldn't meet beyond a reasonable doubt?
That's right.
That doesn't mean I don't think I can meet my lower burden.
I completely agree with that. I think some judges, there are judges that if a case doesn't get indicted or a case gets dismissed, they might take the position, well, my thing is, Judge, just because the DA's office made these decisions for a variety of reasons that we don't know, doesn't mean that this crime didn't occur. And I should have the opportunity, my client should have the opportunity to put her evidence on, because you don't want to substitute your judgment, Judge, for a grand jury. Or because you're there's a different standard, right? And you have a different level of knowledge and expertise. And so we're in a civil legal process, and there's a standard of proof that I have to reach, and you may decide after I put my evidence on that we don't get there. But just because a criminal case has been dismissed is, in my opinion, I agree with you, 100% irrelevant.
Yep.
Yeah. So I guess let's finish up with resources.
Sure.
Because you guys have so many that I think a lot of people don't know about.
Well, talk about Friends of the Family specifically first. We have a whole campaign right now that's called #NotJustAShelter, because most people, when they think about domestic violence agencies, think about us only as a shelter. And the reason that's problematic is if that's the only thing you think about, then most people don't think they need our services. Because if you were getting hurt, your first option wouldn't be to go to an emergency shelter. Right. You would explore your options and choices. If you have financial resources, you would handle it yourself. If you had family or friends, you would go there. So, most people don't want to go to an emergency shelter, at least initially. And so it's so important that folks know the vast majority of people that we help at Friends of the Family don't go to our shelter. They walk in the doors, or they Zoom or virtual. We do a ton of virtual stuff now since COVID, and they get help. And so what the kind of help they can get is, first of all, just an intake to identify what's going on. That's probably one of the biggest helps that you can get is validation and acknowledgement and education about the safety of your situation, right? So that's the first thing. And then from there, they're going to have access to a victim advocate that's going to help them identify and issue spot legal needs, and connect them to legal resources, not just my program, but legal aid and various statewide legal programs. They're going to help them connect to counseling services. We have many support groups that are run by counselors, therapists, and we also have individual counseling. We offer play therapy. We have an incredibly talented director of clinical services, Dr. Kirsten Cram, who runs all of our clinical services, and she is a wonderful expert on children who have witnessed or experienced violence. So we have really wonderful play therapy services. And I don't know if y'all know this, but UNT is one of the founding institutions for play therapy in the world. Did you know that?
No.
So, yeah. So a lot of our play therapists come out of this like internationally recognized play therapy program from UNT. We also use a lot of interns. So it expands our ability to run groups and do individual because we have staff that we can pay. And then we have interns that are getting their clinical hours that expands the number of people that we can see.
So really quickly, I presume that a lot of these services, like the therapy and things of that nature, they're at a reduced rate?
No, they're free. All of the services at Friends of the Family that are on the victim side of the agency are at no cost.
And see, that's one of the things that for us as private attorneys, when we have clients and we're kind of talking to them through these issues, therapy's expensive.
It's
therapy.
Very expensive. Now, there are some really good, even when there's not family violence. So we're a great resource for, victims. Again, across the spectrum. So there doesn't have to be physical abuse, right? If it's emotional abuse, if it's verbal violence, if it's, sexual coercion, if you guys identify that this person has been abused and they could benefit from some therapeutic services, like they can come to Friends of the Family. For folks that maybe don't have family violence issues or domestic violence issues in our community, there are some good reduced rate. Both UNT and TWU have some reduced rate therapeutic programs that use a lot of their students and interns. And then Cumberland, which is Cumberland Family Services, I think is what they changed their name to. They have reduced rate counseling services. So there are good resources for that as well. And you can contact, like a 211 is like an information line through the United Way, and they will know, like they'll have a list of like reduced rate counseling services. But yes, they're hard to get into sometimes, and therapy is expensive. So that's an incredibly valued service. We really try to promote the group-based work that we do, not just because it's we can help more people, but really all the research around victimization in gender-based violence is individual counseling is fine, but group-based counseling is far more effective because when you're sitting in a group of people that have had similar experiences, you start to make some connections and realize that because isolation is a huge part of domestic violence, and so you start to feel less isolated, and you start to understand that what you're experiencing, there's something, unfortunately, something very common about that experience. So you'll have survivors in a group learning or doing some sort of process work or, doing some education work about violence, and they will say, like, man, your guy sounds a lot like my guy. Am I in a movie? Like, are we or do we have the same partner? And it's not that. It's just that the strategies and tactics are, they're very common. And it sometimes feels like people using these tactics and strategies have gone to some kind of training academy for it. Now, on the other side of the agency is our battering intervention and prevention program, where we do provide that 26-week intervention, educational intervention program. There is a cost to that, but it's very nominal. I think it's like $35 a week, and if there is a cost issue, that person can try to address that with our battering intervention program. We don't want cost to be the reason, but sometimes that's the excuse, right? Not to get the help. And so the fee is sort of a part of the accountability process too, right? That you're prioritizing this financially. And so the fee is important, but if you're involved with the child welfare system and they want you to go to a battering intervention program, we have a contract with Texas Child Welfare to provide, the state can pay for the BIP program if they refer that person and they can't afford the person that's being abusive can't afford it. CPS can pay for it. So we have some ways to make that happen. And then also we have some financial assistance, some housing assistance, although that ebbs and flows depending on, housing is probably our biggest barrier in Denton County. It's affordable housing is a massive issue in Denton County, and so we'll have a flow of money in, and it's a big thing to get people safe and into their own places, and we'll run through that money, and then we won't have any for a while, and then we'll get another influx of some funds to help with the housing piece, and then also an expertise with the advocates around crime victims compensation. So in Texas, we have a really good crime victims compensation program. If someone's a victim of family violence, they could be eligible for rent and relocation assistance, which will pay up to a certain amount for deposits and up to another amount, a significant amount for rental assistance as a reimbursement. There's something called loss of support, that if the person using violence was a financial provider to you and a dependent child, you could be eligible for up to, I think it's like $9,300 of loss of support through that crime victims compensation fund. So it's not immediate. It's a governmental agency. It may take 6 months to actually, pry those dollars out of those hands. But that's what we're good at, right? Yeah. That's what those advocates are good at, squeaky wheel, making sure that they have all the paperwork, so the victim doesn't have to worry about it, right? She helps us, then we do that on her behalf, and we're, calling them, what's up? And, our goal is to be enough of a squeaky wheel that they're just like, oh my God, please just send that woman her money so this advocate will stop calling me.
Pay her to go away.
Yeah, exactly. I want them to go away. And it's that persistence that I think we're the most proud of at Friends of the Family, is the persistence with the criminal justice system, making sure that it's working the way it's supposed to work, persistence with the civil legal system, persistence with the child welfare system, just making sure that these systems work the way that we all think that they do, right? And when we think that things work really well for victims, we place a lot of responsibility on them. So it's like, well, why wouldn't she leave? She can get him arrested. She could go to court and get a protective order. She could have a custody order where he can't see his child, right? Like, we have all these very unreasonable expectations that these systems work beautifully, and they honestly don't, but they can. Yeah. And so that's really the piece that we bring to it, is like, we're going to help you. We're the professional that knows how to navigate this system well. And then a lot of the services that we offer, you'll find at other domestic violence agencies across the state of Texas. So you guys are in West Texas. There is no doubt, programs in your area. They may not have legal services programs. Right. We're maybe there's probably about 70 domestic violence agencies with shelters across the state of Texas, but that's for 267 counties.
Yeah, that's crazy. That's
right?
1/3 of the county.
Right. So, and I'm probably, our program for legal services is probably one of 8 or 10 where we have legal services, actual attorneys embedded in the domestic violence program. So our project is relatively rare. So I don't want people watching this to think that every domestic violence program has attorneys, but they should have legal advocates that can help them connect with legal resources. So the best way to find out the closest resource in your area is the National Domestic Violence Hotline, and that number is 1-800-799-SAFE. And they get millions of calls. They know all of the resources all over the country and can target where you need services and tell you what kind of services are available in your area.
Donna, you're so awesome.
Oh, thank you. Awesome. Unless I'm on the other side of a case.
Right, exactly.
Right now you feel I'm very awesome. You might not. Who knows about tomorrow?
But no, seriously, like I've learned a lot about what you all do and the resources available. And I've been practicing with you for, I don't even know how many years, but it's been a long time. And so I really appreciate you taking the time to come out here and to educate us.
Yes.
And every time I have cases with you, you always educate me, and I just appreciate what you do and who you are.
Well, I definitely always try to do that. Sometimes it's welcome and sometimes it's not welcome with opposing counsel. So I'm always so grateful, Christina, that you're willing to hear me out and, take a listen. I will also just highlight again, it's Domestic Violence Awareness Month, and it's almost the end of the month, but on Friday, October 27th, if you will like our Facebook page, please. And our social media people would really love me to make that plug.
And follow.
So follow. Do whatever it is that you do. But at 3:00 on Friday, we will be doing a virtual Facebook Live vigil and be honoring the folks that lost their lives to gender-based violence in 2022. Over 200. I believe the number is 212. It could be 226. I can't remember. It's an unbelievably high number, and it's a horrible thing. And in Denton County alone, 7 homicides in 2022 of those. So we're in the top 10. Not a top 10 that you want to be a member of in the state of Texas, but we are in the top 10. And I think Friends of the Family is working really hard with local law enforcement to try to bring that number down and really focus on. I think we were talking about prevention at the beginning a little bit when I got here, and that's the key, right? Is prevention of family violence altogether, but prevention of that escalated violence, which is why having attorneys like you guys are so important, whether you're on the victim side of it or the alleged perpetrator side of it. Like, our part of our job is we're community members, and our ethical responsibility is to try to alleviate the threat of that escalating violence and help bring that number down. We'd love to see that number come down in Denton County.
Absolutely.
So thank you, guys.
Thank you. So thank you, everyone who is watching us on YouTube and listening to the podcast. Again, we're the Jimenez Law Firm, a Texas-based family law and criminal defense firm. Please make sure that you like us on all social media platforms, TikTok, Facebook, Instagram, if you can find it. Then we're probably there. And then also just a friendly reminder that the things that we talk about on this podcast, it's not legal advice. This is general information. It's experiences that we've had in our cases. If you find yourself in this situation, please, please, please go and find local counsel, tell them your story, and follow their advice.